legal process. The decision appears to have been taken without due process, including the absence of proper consultation, procedural fairness, and lawful grounds. The action is therefore subject to legal challenge. Another point to consider, the board is deeply concerned that this action introduces unnecessary instability in an institution that is responsible for the administration of approximately 2.8 million hectares of land on behalf of the trust. It serves millions of beneficiaries, particularly in rural communities across KwaZulu-Natal. It plays a critical role in land governance, tenure, security, and socio-economic development. So, this abrupt and unlawful intervention risks disrupting ongoing programs. And this board has done a lot of work, by the way. It also undermines investor and stakeholder confidence. And this board has been working very hard to turn things around. Also, it delays critical development initiatives that directly benefit communities. And we had already started that, even when it comes to connectivity in areas that fall under Amakosi, and making sure that learners get registration so that they go back to school or register. So, this undermining of progress, I just want to comment that over the past 3 years, the board has made measurable progress in strengthening governance, improving compliance, and advancing development initiatives aligned with its statutory mandate, as I've just alluded previously. The timing and nature of this decision gives rise to serious concern that it may undo the gains achieved in governance, reform, and institutional stability. It interrupts long-term strategic initiatives designed to uplift rural communities, and it also seeks to reverse efforts aimed at enhancing transparency, accountability, and performance. Bearing in mind that we do receive 24 million allocation from the state, we are accountable to taxpayers, not just in this province only, in the country, because we do utilize taxpayers' funds. So that is why accountability is very important. So the board remains firmly committed to upholding the Constitution of the Republic of South Africa, respecting the rule of law and principles of administrative justice, acting in the best interest of the trust and its beneficiaries. In this regard, ladies and gentlemen, the board is taking urgent legal steps to challenge the minister's decision. It seeks appropriate relief to set aside the unlawful dissolution of the board and to ensure continuity and protection of the trust mandate. So, the board calls upon all stakeholders, including yourselves, including government, traditional leadership, and the public, to respect the rule of law and institutional integrity, to avoid actions that may destabilize governance structures of this organization, and support processes that ensure lawful, transparent, and accountable decision making. So, in conclusion, Ingonyama Trust Board will not stand by while unlawful actions threaten the integrity of the institution, the rule of law, and the interests of millions of beneficiaries. We remain resolute in our duty to protect the trust, to uphold our mandate in terms of the act, and ensure that the progress achieved over the past 3 years, it's not undone in a manner that embarrasses all of us. This is a statement I have prepared, and as I've indicated, I will make sure that you have copies so that I am not quoted out of context. Again, ladies and gentlemen, thank you very much for your time. I now invite. Oh, yeah, thank you. Angibonge izintatheli ezisivakashele, angibonge isikhathi senu. Eh, Sihlangene la ngodaba olungemnandi kodwa lusemqoka, yikho nje ngithi angibonge. Kakhulukazi ngoba iNgonyama Trust Board ngomhla ka-18 March 2026 ithole umbiko wokuthi uminister ungqongqoshe wezomhlaba uyalidissolve, uyalibhidliza i-board. Leli board lithanda ukuthi kwazeke ukuthi lesi sinqumo esithatheke ngendlela engekho emthethweni, i-board ayilisamukeli ngoba umthetho awuzange ulandeleke, ngoba kukhona umthetho olawula leli board, lo mthetho ekuthiwa phecelezi Ngonyama Trust Act. Konke esikwenzayo kulawulwa ileyo mthetho nemigudu esibekiwe. Ikho nje i-board ingakwamukeli lokho. Hhayi ngoba i-board ifuna ukuthi ihlale nje kuthiwani kuze kubuye noma ubani, cha cha cha. Umsebenzi i-board eyaphathiswa wona kukhona isikhathi lokhu i-board ibingakulindele. Kunemthelela ke. Yikho nje na sithena cha asibabize abezindaba futhi bacoshe kithina kungabe amahlebezi nje, ngoba lesi sinqumo esithi asisamukeli isinqumo esibhidlizayo kunokuthi sakhe umsebenzi esiwenze iminyaka emithathu. Leli board kuthiwa alibheke ezomhlaba kuno 2.8 million hectares la KwaZulu Natal, kuhleli futhi abantu la. So umsebenzi wale board ukuthi libheke kwezomhlaba, libheke ukuthi lapho emhlabeni weNgonyama Trust lapho kuzinze khona abantu nalapho befuna ukuthi babe namabhizinisi khona, ukuthi abantu bahleli kanjani, kuhamba kanjani, kukhona na okungenziwa ukuthi izimpilo zabantu zibe ngcono. Umsebenzi waleli board, futhi leli board iminyaka emithathu likhona, cha liwuqalile lo mshikashika ubusaqhubeka futhi. Asithembe ukuthi usazoqhubeka futhi. Kakhulukazi ngoba ikhona imisebenzi ebese siyiqalile, phecelezi ama-program. Bekukhona nabatshali izimali abathi hayi bona bayasaba ukuthi beze KwaZulu Natal mase sithi hayi wozani phela sivula inkundla manje na ukuthi kube khona amabhizinisi. Laba abavela ngaphandle hayi bebethi nje kodwa sakusebenza lokho ukuthi babone ukuthi kuyaphileka, kuyasebenzeka futhi bayathola ne-support nokuxhumana nebhodi. Bebefika la sibalalele benze izethulo ngoba sithanda kube khona uzinzo ey'ndaweni ezingaphansi komhlaba wengonyama. So lesi sinqumo sikubhidliza konke lokho, sibuyisele emuva. Lesi sinqumo sikaNdunankulu uNdunankulu usithathe ungqongqoshe sorry ungqongqoshe usithathe ngalesi sikhathi esithi isikhathi esibucayi ngoba hayi cha lesi sitimela besihamba futhi bekuba mnandi ukuthi siyabona ukuthi siyakuphi. Yikho nje sibonga ukuthi nisilalele. Nasi isicelo esisenzayo njengebhodi, njengoba sesibekile. Siye enkantolo ngoba into engcono ukuthi kungcono kulamule inkantolo. Inkantolo ayisazi, inkantolo ayimazi ungqongqoshe, kungcono ke kuzwakale enkantolo ukuthi kwenze njani. Yini le enkulu kangaka eyenzekile kube sengathi kuney'gebengu lana ibhodi eyigebengu ngoba ungqongqoshe wenze isimemezelo ngomhla ka-18 umhlangano ubuqale ngo9:30. Hawu, mina ebusuku sekukhona nayo incwadi isilandela konke nje nakulandela abantu abasakwazi nokuthi mhlawumbe kungathiwa-ke hhayi ake nixoxeni nenzoma close out report. You can't run an organization like that. Kakhulukazi kubantu abanjengathi thina sihlonipha nje ukuthi siyithina, ukuthi besiphathiswe umsebenzi ngokuthembeka. Uma siphuma hayi kungcono siphume kahle, hayi kanje. Yikho sibone ukuthi asiluthathe lo daba silise enkantolo silubeke sizwe ukuthi amajaji athini wona ngoba thina sithi ayi akuhambanga kahle, umthetho awulandelwanga, asijelwanga nalezono ey'nkulu ezenza ukuthi kuthiwa ibhodi hhayi ayimashe iphume. Simi lapho nje siyalithatha lolu daba siluyisa enkantolo yamajaji amakhulu. Angibonge.
Thank you, everyone. Maybe let me start with a general apology for my language. I'm generally not very good at Zulu speaking, and so as a consequence, a lot of my construction and terminology does slip. To those that might be offended by some of the words that I might have used, I apologize. Our sole intention, though, today is to place some facts on record, once and for all, regarding the ongoing crisis surrounding the Ngonyama Trust Board, the actors involved, the unlawful disruption of the board's work. There has been a sustained public narrative that this board is dysfunctional, rogue, or incapable of governing. That narrative is false. It is legally unsound. It is factually misleading and increasingly appears designed to justify intervention, that which in itself is unlawful. Today we will speak to all of the facts. The board first met the Honourable Minister on the 22nd of October in 2024 at his offices on 600 Liliengo Street in Pretoria. This was the first engagement between the board and the minister since the announcement of the 7th Administration Cabinet on 30 June 2024. It is important to state at the onset that this meeting was initiated by the board and not by the minister. The board sought to introduce itself and formally greet the minister. The facts matter. This fact matters because it says much about the nature of the relationship that follows. At the meeting, the tone of the relationship was, in our view, also very much set. The minister's remarks and those of persons invited by him to attend in support of his position were surprising and deeply concerning. The minister had with him the Deputy Minister of Cooperative Governance and Traditional Affairs, Deputy Minister Ben Mamash. A presentation was made on behalf of the board by the vice chair, sitting on my right, Advocate Lindaza. In response, the minister stated plainly that he believed the board should resign. That sentiment was echoed by those present with him. The basis advanced was twofold. Firstly, the board was not getting along with His Majesty, and secondly, the minister himself had not appointed this board. At that point, one of the board members insisted that mediation rather be undertaken. The minister agreed to mediate the situation between the board and His Majesty, and to date, though, no such mediation has materialized, nor has the board received any meaningful feedback from the minister. That is significant because it reflects from the outset a pattern of non-engagement, non-resolution, and avoidance of lawful supervisory responsibilities by the minister. The role of the minister in relation to the Ngonyama Trust Board is not vague. It is defined in law. The KwaZulu-Natal Ngonyama Trust Act, particularly Section 2A, 3B, and C, requires the minister to appoint members of the board. Section 2A7 requires the minister to make regulations governing, amongst other things, the circumstances under which board members vacate office, the manner in which meetings are convened, the powers and duties of the chairperson, the vice chairperson, and the acting chairperson, the quorum and procedures for meetings, the keeping of minutes and registers and records of the board, and any such other matters that are necessary or useful for the attainment of the objects of the Act. The minister's responsibilities are also extended through administrative and financial regulations to the Act. These include determining board regulation in consultation with the Minister of Finance, determining the first meeting in consultation with His Majesty and the Premier of the board, receiving notification where quorum is not attained, and setting the date by which the board must submit its annual report. These are not symbolic powers, they are legal tools for supervision. If a board is allegedly not performing, the minister has statutory mechanisms available to him to deal with such non-performance. What is before the country today is not a minister exercising those tools competently. It is a minister who appears either unwillingly or unable to read, apply, or amend the very regulatory framework under which this board operates, and is instead attempting to govern outside of it. The board's position is simple. The minister has not yet played a supervisory role assigned to him by law. We now turn to the report given by the minister to the Portfolio Committee on Land Reform and Rural Development on the 18th of March 2026, which we believe has emboldened the present unlawful course of action. The minister told Parliament that the department is dealing with an ongoing investigation, governance constraints within the board, and active legal proceedings. He stated that Advocate Morumo Mwelane, appointed by himself, is investigating matters including executive contracts, procurement compliance, financial management, and the relationship between the board and the trustee. The board denies that there is any investigation presently underway, in law or in fact, whose scope has been lawfully communicated to it and in which it is participating. These are the facts from the board's perspective. As early as the 23rd of April 2004, the board met at the instance of His Majesty. At this meeting, His Majesty was accompanied by Mr. Thulasizwe Killing. A contract which had been drafted by a firm of attorneys appointing those attorneys as legal representatives of the board and the trust, and to conduct an investigation was read out. The PFMA and procurement compliance were raised through the meeting by the board. It was also noted that the board had previously requested Minister Titiza to initiate a similar investigation into the affairs of previous boards, as the then state of affairs was deeply concerning. His Majesty had earlier requested Mr. Ngwenya, while he was chairperson, to speak to such allegations of financial mismanagement during his time and provide a report to the nation, which Mr. Ngwenya purported to do publicly on Kozi FM. The board reiterates that there is a need for investigation in past affairs. It is also not averse to scrutiny of its own action. On the contrary, it welcomes such scrutiny. It believes it has performed exceptionally well under difficult conditions, and that any fair, properly scoped investigation will confirm that. On the 20th of September 2025, the minister called the board to Pretoria and informed it that Advocate Moromo Morane had been appointed to conduct the long-awaited investigation. The minister undertook to furnish the board with terms of reference by the 21st of September 2025, which was the Sunday, so that the board could ensure that the scope was comprehensive and that it covered the appropriate periods. The terms of reference documents was never sent to the board. So when the minister now says that he and his department have consulted stakeholders on the governance framework, including the Royal Palace, the board must say this plainly. One of the central stakeholders in such a process ought to have been the board itself. Yet the board was never given the terms of reference, never engaged with scope, never given methodology, never told who the forensic firm was. In fact, we heard through the media that Advocate Morane insisted that a forensic firm such as Deloitte or PwC be appointed. And the board has never been approached for documentation by any investigator acting on a disclosed mandate. We therefore state categorically that there is no investigation in which the board is presently participating. Once a lawful, properly scoped process is disclosed, the board will cooperate. We also note that the minister has publicly stated that there will be a report available on the 18th of May 2026. That is remarkable given that the board has never even received terms of reference. The minister's current position appears to be that the board's attrition has rendered the board unable to function. This is a legally and factually defective position. Administrative Regulation 3.2 provides that whenever the office of a member becomes vacant before the expiry of the period for which he or she was appointed, a replacement must be appointed in the same manner as the vacating member for the unexpired portion of their term. In other words, the lawful response to vacancies is not institutional panic, political narrative, or extra statutory interventions. The lawful response is appointment of those who have vacated and refilling those posts. The first board member to leave resigned on the 22nd of September 2024. Coincidentally, that was the time we actually met, being Ms. Lisa Del Grande. The next was in September on the 9th of January 2025. The next was Mr. Matamela, who would resign and transmit his letter in November 2025. But his resignation was effective on the 26th. He served a 3-month period and expressly in his resignation letter requested that a replacement be appointed in terms of Regulation 3.2, giving the minister until the end of February. The minister neither responded nor acted. As far as the board knows, those are the members who have resigned. On the 10th of March, board members received letters from the minister stating that he had consulted His Majesty and the Premier, and that on the basis of attrition, he intended to terminate the remaining members of the board. We note with that letter that there was no consultation done with the House of Traditional Khoisan Leaders, which is an important element and a legal element for these consultations. In that letter, he stated that there were now 4 members and His Majesty. That is the point at which the board first inferred that Dr. Dlamini may also have resigned. An email was sent to the Minister's Chief of Staff, Mr. Kaba, on the 12th of March 2026, querying Dr. Dlamini's status, and the response indicated that she had indeed resigned. A resignation letter was requested and remains awaited from the department and the minister. The board has also not been able to reach Dr. Dlamini. Even on that version, there remains 5 board members, including His Majesty. It is irrational and bizarre that His Majesty's non-attendance is now seemingly being treated as though it amounts to an effective resignation. The law does not permit that. The minister is therefore attempting to convert a vacancy management problem, which the law requires him to address, into a justification for terminating the very members who remain. That is a self-created crisis. It is not governance. It is not supervision. It is administrative failures dressed up as intervention. The minister has now alluded to the appointment of an administrator and indicated in Parliament that such intervention had the concurrence of the Minister of Finance. This position is legally untenable. Section 49 of the Public Finance Management Act provides that where public entities has a board, that board is the accounting authority. That position remains unless and until a lawful determination is made in terms of the PFMA. The PFMA does not contemplate a line function minister creating a vacuum and then appointing an administrator to fill it. nor does it contemplate a system of concurrence by the Minister of Finance to validate an otherwise unlawful displacement of an accounting authority. The power to recognize or designate an alternate accounting authority in exceptional circumstances vests with the Minister of Finance and not the Minister of Land Reform and Rural Development. This is why the board has written formally to the Minister of Finance seeking clarity whether any such determination was in fact made. If so, on what legal basis and through what process? This was necessary because statements made in Parliament suggest that some form of consultation or concurrence may have been invoked to justify the intervention. The board has placed on record its concerns that any such conditions or consultations, if occurred, may have been based on incomplete or inaccurate representations of both the factual position and the law. The statutory scheme does not permit a line minister to create a governance vacuum and then rely on that vacuum to justify imposition of alternate structures. Vacancies must be addressed through proper appointments, not by passing or displacing the accounting authority. Accordingly, the proposed administrator arrangement is, in the board's view, unlawful, ultra vires, and inconsistent with Section 49 of the PFMA. The minister's public statement on this issue is also inconsistent with the legal position reflected in the board's own media statement on the 18th of March. The minister has also created a misleading impression that the board has failed in relation to financial reporting. The annual financial statements of the board are audited public documents. They have been submitted as required for the purposes of consolidation into the government financial statements. The board's audited annual financial statements, as a Schedule 3A Public Finance Management Act entity, are governed by Section 55 of the Act. What the minister appears to be referring to when he refers to the financial statements of the board, though not accurately, is the annual report. There is a lawful explanation for the delay, and the minister is lawfully and fully aware of it. On or around the 4th of September, 2 letters were transmitted for the minister's signature for the National Assembly and the National Council of Provinces in terms of Section 65 of the PFMA. Those letters explained that while the audit of Ingonyama Trust Board had been finalized and reported on by the AG, the audit of Ingonyama Trust had not yet commenced because the accounting authority had not yet approved the set of financial statements for audit. This arose principally from the long-standing challenge of constructing a land register capable of properly accounting for land held by the trust, which is, by the way, a capability that the department has within their competency and could have assisted the board if they really are interested in the board's performance. The letter explained in substance that the approval date for the trust annual financial statements has now been set to the 31st of January 2026, which is within the rights of the board in accordance with financial regulations to set a date for approval of financials. The Auditor General had, as a consequence of that commitment, undertaken to submit a complete audit report within 2 months in accordance with the Public Audit Act of those approved statements, which would be no later than the 12th of April 2026. And the board then committed to finalize in those letters to Parliament and the National Council of Provinces to submit the complete annual report of both the board and the trust by 15 April 2026. The letter was tabled. It forms part of an official public record. It cannot now honestly be repackaged as evidence of delineation. In December 2025, the board closed the procurement process and appointed a service provider to reconstruct the land register. On 12 February 2026, the board approved the trust annual financial statements for audit. The audit is currently underway, and as recently as yesterday, we're discussing the resolve of audit findings. The prior year's qualification related to land, accounting, and non-consolidation of Ingonyama holdings. It would have been irresponsible for any board to knowingly approve annual financial statements if it knew they were materially misstated. The board will not apologize for insisting on accuracy rather than convenience. The minister's statements on these matters reveal either a lack of understanding of the financial governance framework or a willingness to distort it publicly. Neither is acceptable. There has now been a shift of focus to me personally and my employment status. That effort appears to be driven in part by senior officials of the department who themselves do not appear to be willing to read and apply the law properly. The minister has referred to me in personal terms and allegedly instructed that I must be removed. Those statements are deeply improper and are personal, malicious, and dangerous. On the 8th of March, at approximately 12:41, Mr. Heyman, the Acting Director General of the department, requested, ostensibly for record-keeping purposes, the employment contractual instrument applicable to my current assignment, referring to my assignment as Acting Head of Secretariat from the Vice Chair. On the 9th of March, Mr. Heyman received a board resolution dated 27 June 2025, together with an acting appointment letter. His stance then shifted. What appears to be sought is not a lawful clarification, but leverage to carry out a lawful instruction. The facts of my employments are straightforward. I was seconded to Ingonyama Trust from the 1st of May 2021 by Minister Didiza after extensive governance, finance, and audit issues at the institution had been repeatedly reported to Parliament by the Auditor General. The secondment ended on the 31st of December 2023. Thereafter, the board offered me a fixed-term contract until 31 December 2024. Intending to advertise the post, the recruitment process was delayed for governance reasons, including the conduct of Dr. Lamini, who sought reference information from the department before the recruitment process had properly unfolded. The HR committee was disbanded by the board and reconstituted as the entire board, which prolonged the process further. On the 10th of December, the board resolved to extend my contract from 1 January 2025 to 31 April 2025 to ensure continuity in financial leadership while recruitment proceeded. On the 10th of April 2025, the board further extended my contract for a further 6 months from 1 May 2025 until October. A recruitment agent was later appointed on the 30th of June 2025 to begin the recruitment process. On 28 October, the board approved a further 6-month extension from 1 November until the earlier of 6 months or when the position is filled. On the 27th of June, the board had resolved to assign me on an acting basis as caretaker until the head of secretariat was appointed, effective 1 July 2025. On or about 6 and 7 January 2026, the board, assisted by the recruitment agent, interviewed 10 shortlisted candidates and appointed me substantively as the Chief Financial Officer with effect from 1 February 2026. I am currently acting as the Chief Executive Officer. The CEO position is not my substantive post. All this is contained in my employee file and is subject to proper legal labor, including audit information governance rules. What is now being attempted is not a lawful administration, but unauthorized extortion of control over Ingonyama Trust employees who report to the board, not to the department. On the 28th of May, the Ingonyama Trust was served with a review application by Mr. Sipho Jerome Ngwenya, the former judge and previous chairperson of the board. The application was against the minister, the premier, and other respondents. The Ingonyama Trust, the Ingonyama Trust board, the then CEO, and the CFO were amongst the 13 respondents that were cited. The relief sought includes the setting aside the appointment of the interim board, which Mr. Ngwenya was part of, and was the board that created Ingonyama Holdings in November 2019, declaring the appointment of the current board invalid, setting aside the appointment of the CEO and CFO, and setting aside all decisions taken by the allegedly unlawful board. Following the meeting on the 20th of September 2025, the board committed to send the minister, which was our second meeting with the minister. The board were one of only two. The board committed to send minister a report of all legal matters requiring his intervention. That report was transmitted on the 29th of September 2025 and recorded that as at that stage, the minister and the department had not filed a notice to either oppose or abide by Mr. Ngwenya's prayers. Initially, the minister had advised that he would not oppose the application, effectively abiding and expressing the same sentiments that he had expressed when he met the board for the first time about its appointment. After the board had briefed the portfolio committee on the consequences of such an approach and minister abiding by the prayers of Mr. Ngwenya, the 10th of September, a notice was then filed on behalf of the minister by the state attorney. On the 8th of September, a record was transmitted by the minister and filed. On the 9th of September, the matter came before court for hearing, and the parties were placed on terms to deliver answering affidavits by the 19th of December. The board delivered an answering affidavit on the 19th of December. To date, the board has no record of the minister having filed his affidavit as directed by the court. The board has since set the matter down for hearing on the 27th of April, and this was now set on an unopposed roll because the minister, as primary respondent, has not filed any papers. The board has protested this. At the same time, the department has appointed Advocate Mwerane, who is said investigator to the board, while he's also now in litigation representing the minister. The conflict becomes obvious. The suggestion that the department's position is fully reflected, therefore, in court papers is simply false. The department has not done the work it should have done in the litigation. Instead, it is now attempting to fight the board through other means. The country must understand the broader background. Mr. Ngwenya has been at the center of Ngwenyama Trust system since 2001, first in an acting capacity and later as royal nominee. He had over 2 decades to shape this institution around the statutory requirements and make sure that it operates for the benefit, material welfare, and social well-being of the communities listed in the schedule to the Act. In the board's view, he failed to do so. Instead, this board has had to confront a legacy of problems, extraordinary serious problems, including investigations into misappropriation of funds and land-related irregularities. The board is currently dealing with matters involving over 75 million rand that it has managed to uncover, including a Hawks matter relating to Ngwenyama Holdings of 41 million, which is sitting currently with the NPA, a matter concerning approximately 35 million arising from the sale of Hammersdale, which has already been decided on by the court, and we are actually attaching assets and proceeding with the attachment order on that. And other matters, including the mining sector, occurring in the mining sector, which we cannot publicly disclose right now because they are quite sensitive at an infant stage. All of these make the board be ready to approach the president for a proclamation request for the SIU to look into the vast web of these occurrences. Mr. Ngwenya plainly stands to benefit if this board is dissolved and its decisions reversed. The tragedy is that the minister appears not to appreciate whose game he's actually playing. On the 6th of November 2025, the board resolved to convene a 3-day strategic engagement forum with traditional and community authorities. This was a significant and widely publicized event. It followed extensive reflection on the state of the institution and sought not to only account for the past, but to pave a corrective and collaborative way forward in the very traditional authorities the law requires the trust to work with. The board resolved to write to His Majesty requesting audience to appraise him of the event. The board was met with silence from his private office, or the private office of His Majesty, and eventually abandoned further efforts after repeated attempts. The event began at full capacity at the ICC on the 8th of December 2025. During the opening proceedings, Mr. Thulathisizwe Buthelezi, acting as traditional prime minister, requested to introduce the members of the royal family who had been sent by His Majesty. This gave the board the impression that His Majesty or his office was aware of the forum. It was then, to the board and many attendees' surprise, that Mr. Thulathisizwe Buthelezi proceeded, which is what we consider utter disrespect, proceeded to read a letter from the minister addressed to His Majesty. He stated that he had received it from the minister. The letter purported to consult His Majesty on the precautionary suspension of the board pending the Mwerane investigation. This was read together with an earlier correspondence dating around 2004 from His Majesty. In the board's view, this was part of a broader attempt to disrupt the event and delegitimize the board's word. The event was impacted negatively, yes, but it did not collapse. This is another false narrative that must be corrected. The board has improved this institution. As of the 31st of March 2025, the board received an unqualified audit report with no findings on its annual financial statements. That means that the Auditor General accepts that the statements fairly reflect what the board has said it has done. The board has improved efficiency of processing applications by approximately 90%, as reflected in the quarterly reports that the minister now claims to have not received. In fact, on Wednesday, we are invited to Parliament to account for the third quarter report, which would have gone past the minister. Irregular expenditure at the board as at 31 March 2022, during the period when Mr. Ngwenya was chairperson, stood at 29,608,000. As of 31 March 2025, under this board, the figure is 79,000. The allegations of dysfunction are therefore not supported by public reports. On the question of benefit to Amakhosi and communities, the board has sought to address this in Parliament through quarterly presentations on disbursements. Those disbursements have improved materially. From about 2019, Ngonyama Trust Board, under Mr. Ngwenya, issued 7.2 million as disbursements. In 2020, the figure would drop to 6,605,000. In 2021, under Mr. Ngwenya, the figure would increase to 8,736,000. In 2022, that number would be 7,971,000. The board got appointed in May 2023 and became quite resolute about disbursements to communities. The 2023 disbursements figure was 19,608,000. The 2024 disbursement figure was 46,170,000. The 2025 figure was 55,303,000. The 2026 figure up to the end of February is 56,767,000. This is the record of a board who is working to ensure that communities benefit. Any person who genuinely wishes to understand how well or poorly this board has performed should read and compare annual reports, audit reports, and annual financial statements that are publicly available. In December 2025, the minister sought to consult His Majesty, the House of Traditional Khoisan leaders in KwaZulu-Natal, and the Premier regarding the placement of the board on special leave pending investigation. The board knew nothing of the supposed investigation, its terms and scope or process, except for what was disclosed in the meeting with the minister in September. The board is aware that responses to those consultations raised concerns regarding the legality and the continuity arrangements. To the board's knowledge, those concerns raised by the Premier and by the House were never addressed. On 11 December 2025, the board resolved to brief its attorneys, who in turn wrote to the minister recording grave concerns regarding the contemplated placement of board members on special leave, which was in substance was amounting to the suspension of the board. The attorney pointed out that neither the Act nor the regulation gave the minister the power to suspend board members, and that such action would violate the principle of legality. They further reported that no lawful process had been followed, and the board members had not been furnished with charges or afforded a procedurally fair opportunity to respond. No response was received from this communication. Thereafter, on the 10th of March, letters were transmitted to board members indicating an intention to terminate their board membership, purportedly on the basis of governance instability arising from attrition. Members were given only 3 business days to respond. No specific allegations or misconduct were articulated. The board, through its attorneys, responded by the 12th of March 2026, recording that the process was purportedly hollow, irrational, and unlawful. On the 18th of March at approximately 23:18 in the evening, towards midnight, members of the board began receiving letters terminating their membership with immediate effect, retrospectively with effect from 8 a.m. in the morning that day. We view this and believe that it is nefarious. The letters asserted that sufficient and lawful grounds existed, including breakdown in governance relationships, internal divisions, attrition, and instability. They also indicated that an administrator would be designated. The board has considered the decision not, or has taken the decision not to abide by the purported termination because it is advised that the action is unlawful, irrational, and inconsistent with statutory frameworks. The board is a creature of statute. It cannot lawfully give effect to unlawful instructions. This is not defiance, it is the fidelity to rule of law. The board understands and takes seriously its mandate to administer the trust for the benefit, material welfare, and social well-being of communities for whom the land is held. That is precisely why it will not be shaken by unlawful tactics, administrative improvisation, or manufactured narratives of dysfunction. This is not a lawless space. It is not a place for political theater. It is not a place for private agendas. It is a statutory institution with legal obligations to millions of people. We have work to do. We intend continuing doing that work lawfully, professionally, and in the interest of the communities we serve. Thank you very much. Don't do the Zulu thing. I need a break.
No, thanks, Coach. Thanks.
I think the Zulu thing we can do sound bites.
You'll end up messing up.
Mm. I'll end up having to apologize again for my language.
Right.
Ready for some questions?
Let me just get my notebook.
Yes, colleagues, you are ready. If anyone who would like to ask something, let's see by the show of hands. I'll give you numbers. 1, 2. Think about it. Okay, so it's 2 hands.
Then can you
Yes,
introduce yourself?
Let's order, so everyone can colleagues in order process. Introducing yourself, and the help of the and then you can ask the question.
Hi, colleagues. My name is Bongani Han from the Journalist for Independent News. I would like to find out, there are a couple of questions that I would like to clarity seeking questions. I would like to find out when is the board going to approach the court? Is the actual date when are you going to approach the court? Because they drafted the papers. Can you please share the papers of possible?
Thank you.
Okay. All right.
You also understand what you're asking.
Okay. Then you were given letters to vacate with immediate effect, but I'm talking about the board.
Mm.
I don't know whether you are saying, oh, you are not a member of the board, so that those letters do not apply to you.
Yeah.
Why is it not? Is it not? Uh, how do I put it? Are you not here by force? You are in this building, whereas you are giving the letter to vacate the office. Then also, you are saying that the board, the minister did not consult the House of Traditional Leaders. Is the king not the custodian of the traditional leaders once he's been consulted? Because it seems as if the minister has already addressed the king on this matter, and he also addressed the premier on this matter. Yet the premier came to say that yeah, he has been so he accepted the quantitative decision that has been taken.
The last one.
When was the board's term of office to 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 end the actual date?
Yes, number 2.
That's good.
Yeah, no, it's fine.
I know it's fine.
No, it's fine. Can I take 3 questions from number 2?
My name is Khaled Khaled from CTC.
Sorry.
Sorry, name?
Khaled Saban.
Okay.
Bowman has started this issue of but mine is you have already mentioned that you have already mentioned yesterday that the Amapos are not but if first of all outside privately, if you consult them, what is their attitude over this issue? What do you say? Do they support the approach of the the law? So the second thing is if you can document that CEO that this is not a political space. Do you suspect that perhaps the deployment of the board is political motivated?
Thank you. Vice Chair, say.
Okay. Yeah. Nico, you start.
All right. Thank you, colleagues. Thank you very much. Um, no, see, if this is the most simplest thing. If you're being asked to do something unlawful, something illegal, you don't oblige it. That's the rules of this country. Our view, as we've already said, the view of the board, is that these instructions, considering all the facts, considering the context, are not legal, which is why we're saying let rather a competent court um, make a decision and profess to this. So whether we are here by force or not is not a question for us. We're not going to be able to force the stopping of the working of the Yama Trust Board through a wooden of paper that we think is illegal. It must only be ventilated in court in a piece of paper. However, what we see and hear from this conversation is that we are securely at risk because if we are then sitting here by force, that implies that we must be removed by force, and it's a dangerous rhetoric. Sorry, no, we're not here by force. We're here because we have been advised so legally that the actions are unlawful. If a cabinet minister, the vice chair normally says, even the president instructs you to do something illegal, you have the right to refuse that illegal and unlawful instruction. Even within the rules of labor, employees are allowed to refuse unlawful and illegal instructions that are unreasonable. So that's exactly what the board has done. With regards to the consultation of the House, the law is quite clear in that it makes provision for consultation in three folds. Section B, Schedule 2A, of paragraph 2A, 3, and part C. And they all include, in one way or another, a direct consultation with ECLO. And that consultation explained as to why, because in that instance, ECLO is being consulted as ECLO Samaban, not as the chairperson of the board. The Premier is consulted because of the interests, regional interests. The Act says that. So those must be balanced because the Banyana Trust has a vast coordinating and administrative mandate that spans across the province, including traversing areas that provincial government is responsible for. The third person is the House because the structure that is legally existing right now under the Governance Framework Act, Traditional Leadership Governance Framework Act, is the Provincial House of Traditional and Consent Leaders. Each province has one, and all houses report to the National House. Now, that is a direct legal requirement. So if we are hypothesizing what the structures are in accordance with our customs, we need to then test that in accordance with the Roman Dutch law that's written down and come to a conclusion, and often those conclusions are ventilated in the improvement of that law and then are codified into legislation. What we won't do is we won't entertain academic discussions of whether this is that or that. The law requires consultation with the House. What the board envisaged that consultation going to be speaks to the effective working of the House itself, because represented within the provincial House are local houses. So for us, that provincial House is a perfect structure for dissemination of messages when it comes to the operations of the Banyana Trust. That was then why Mr. Philosopher Telezi issued an instruction of COPTA to every employee and every other stakeholder that COPTA must not work within the Banyana Trust. The structuring mechanisms must be separated from the political area in which we are constantly being drawn to play into. If everyone is listening to us, we are saying, please create a direct separation between umsebenzi, the work of the Banyana Trust Board, and the politics surrounding. We are quite clearly aware about what the media narrative that is presented out there about us. We do media monitoring, and we are quite clear that we are being framed as a conflicted governance/royal model of land administration. This is a development institution. It needs to be accorded that right, and therefore the introspections or the probes that go into it must be aligned with the question of development. What have previous boards and the current board done to ensure developmental potential of the Wanyama Trust land and to ensure that the benefit, material welfare, and social welfare of these communities is dealt with. With regards to the question that Mbete also asked, what the board feels as the feeling of Makos on the ground. It's not a feeling, there's a statement that was issued out. We don't like creating factionalization. Our work is simple, it's based on the law. Now, Amakos have issued, in a particular forum, have issued a statement that detests what's actually happening and they're condemning it. The statement is available, it arrived to us in solidarity. We're not going to publish it, but we make it available because it's not our place. It's that institution of Amakosi who are at liberty to publish that. We work with Amakosi quite closely. Even the media statements, we have a broadcast group where we share all of these things. And our daily work is actually continuing. It's sad then. In fact, yesterday I had to turn around. I was going to Esho to go meet with Inkosi Mpungose and his traditional council because he wants to develop an economic zone. So we had to have those discussions and how we structure the equity of that. And that work got disrupted because of this. And we had to come back and consult lawyers and deal with our approach to court. So my plea is, yes, let's deal with the facts and the sound bites and what excites the media. But the reality of the end of the day is we need to seek development, which is what we are saying to Izizwe. Izizwe need to ask themselves the questions. Have we been benefiting? We're sitting here as beneficiaries. Sizalwa ey'ndaweni zamakhosi. So as a consequence, we have not seen beneficiation up to our age. And we are saying to everyone who is a beneficiary, you're a trust fund baby. How have you benefited? And that conversation is a lengthy conversation that we are having. And everyone who looks at these discussions must look at them as disruptions to that particular agenda. When is the board term effectively ending? Advocate Zama is the first member who was appointed early and was designated by the minister as the vice chair, whose term comes to an end in December. The other members' terms start coming to an end around March, the last one being in May 2023. So effectively, by the end of May, we will actually have no board. The question that everyone should be asking is, what process is minister undertaking to actually replace or fill up the board members in accordance with Regulation 2? But more importantly, what is the minister doing to actually start the recruitment process of the oncoming board? Because we are watching the caliber of board members that are going to arrive. The law is clear. Qualified members of the board need to serve in this board. The law explains what those qualifications are. And we're going to be ready to review those decisions too, because we as a secretariat can no longer be subjected to this instability. We need a board who's going to support the ideas that we have, and a board that is going to be supportive of a mandate that is a long-term mandate that actually makes sense. Is this political disbandment? I don't think so. I think it's just clumsy behavior by certain functionaries who do happen to be political figureheads. But when we deal with them, we don't deal with them as politicians. We deal with them as members of executives and members of cabinets, etc. So this is just our honorable minister not really paying effective attention to his role and his duties. So we don't think there's political interference to that extent, but we do think that there is incompetence, and we do think that there is delineation of duties by certain functionaries, particularly employees of the department. Right.
Um, could I just comment on Amakosi? This organization, for the first time, decided to bring Amakosi Nezinduna under one roof on the 8th of December 2026. And the reason this board decided to do that, it's because it was concerning to us that Amakosi, first of all, did not know this organization. They did not even have information on how to apply for funds. They were sitting there. That is why you were seeing the figures very low, because Amakosi, who were accepted by the former chairperson, at least had access. And then we come and say, hey, beneficiaries are beneficiaries, and they didn't have that information. You would find a traditional council not knowing that they have 1.2 million rand sitting in their account. So we've been opening communication, and we flowing from the December engagement, we have programs to continue to engage, because it's not everybody was at the ICC. So we then decided that we're not going to be this board uh, that is just elitist, etc. There are other members of Mkhandlu who were not in Durban at the ICC. So we've covered two region districts so far, so that the board accounts share. When you sit there and listen to interactions, questions, the questions are so basic. Say, wow, so they don't know this, that sort of thing. So, speaking for myself, from the 18th of March, Amakose are phoning. All right. And you don't say much, if you're a leader, you are also not alarmist, etc. But as individuals, including Izinduna, this morning there was an Induna, and just when they say we pray for you, and then I say we accept those prayers, we appreciate, they appreciate. Having said that, ladies and gentlemen, let us not forget that Amakosi are subjects of the king. What I have learned, I thought I know my province, but what I have learned is that um, people are so afraid that they would rather, call you direct, etc., and share what they're scared. After all, they even say "Kunenkabi" in this province. There is fear. I know that I'm going to quote him because he's sitting next to me. Because uh, people have been alarmed when he says, "No, all of us will die." He says that, and then I'm reminded that, oh, by the way, I also just carry on with the service and forget about these things. But let us be honest with you, people are afraid, and they are also afraid because they get stipends from government. A stipend is in Duna. So they are subjects, they get stipends, and there is this culture. We seem to be very modern because we are outspoken, but there is this culture of being afraid. And it's just sad. It is sad, yeah. But there are quite a number of them. Even Izinduna phoning, oh, they say they're praying for us. Okay, prayers are prayers, and we just need to accept these prayers. Thank you.
Can you take the last two?
Yes.
Okay.
I'm waiting up.
Okay, yeah, that's last two.
There's a question that you did not answer when chair or the CEO. The question about going to court, the court date.
All right.
Oh, yeah.
And also you also mentioned the you also mentioned Advocate Zama's term of office in December. I don't know which
2026.
26.
Yeah.
2026.
Yeah.
We can just check. Anything, anyone? What's last closing? Nothing. Okay, thank you.
All right.
You can go
We're not going to give you our papers. You'll get them when they become public record, because that gives out our strategy. We are filing today. Hopefully, we'll be in court on Monday or Tuesday.
Um, yes, I'm glad you are giving me that opportunity. Ladies and gentlemen, we have beneficiaries. Amakosi, we have staff members here who had been exposed to management, I don't know how they survived. I'm raising this because I think about our staff members here, the disruption. And I think about the fact that they were beginning to come to terms with the fact that having been traumatized psychologically by leadership and management, that was destroying them as human beings. They were beginning to feel that there is something different. We have even gone further. You know, I was talking to our manager um, from the HR side. For the first time, we have our staff who appreciate the fact that in addition to being employed here, we care for their health and safety, mentally, emotionally, etc. That has been foreign here. And I want that to be recorded. And it's not just the individuals who walk through that gate, they have families, they have children who have to go to school and be the best they can be. And from outside, there are people who really are committed to disrupting this organization that has been pulling together the loose strands and making sure that our staff begin to understand who they are and that they are appreciated and that they matter so that they are of service to traditional councils, etc. In December, all of them, all of them, the 44, they were at the ICC because we wanted them to experience what it is to be members of this organization. That's, I feel very strong about this because there was something in me that just said, my word, some of us have, we have fought here. We have even fought for a free press. We have fought so that at least there could be a better life. We did not fight to even make amakosi in rural areas blindfolded because they didn't know. There is something I'm very passionate about that at least let us leave a scratch, just a tiny little scratch, so that they can say, there, there was that board, but we don't want to be portrayed like rogues, incompetent, non-compliant, disrespectful. It was said in Parliament that we disrespect our chairperson, that we disrespect the minister. At this day and age, me, oh no, oh no. Uh, it is, it's, it is unacceptable to manipulate and abuse your condition, your position, if you are a leader, to gain something that will destroy other people. It is unacceptable, and I do want that to be recorded. Leaders have no right in this country to destroy everybody, black, white, green, purple, and whatever. We don't have that right if we are leaders. And we don't expect leaders who are even at a higher position than ourselves to lead in that manner, because that is not what this country is about. Thank you.
No, thank you very much.
Right.
For coming.
Again, everyone, we're the ones we've been waiting for. No one's coming to save anyone.
Yeah, No, 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 never communication.
Yes,